that this case is all about ownership of copyright, the different classes of copyright that exist in musical and artistic works, and distribution of royalties with respect to the classes of rights.
I'm writing.
Apologies, Mary. The defendants will show that the plaintiff's claim is not merited, and her claim is based on rights not known in law, distribution of royalties with respect to the artistic works in which the plaintiff was involved in was fairly undertaken, and we shall demonstrate that this claim is not merited. That is all for opening remark, my lady.
Okay.
I have one witness. I request that the witness be sworn, my lady.
And nothing but the truth. So help me God. I'm a lawyer by training.
What is the relationship with the defendants, the first defendant to the fifth defendant in this case?
I'm a co-director in the business Soul Generation Record with them, and also I've been the general counsel of the group of businesses that they founded and run.
What is the name of the business they founded and run?
Soul Generation Records.
And what's your relationship with Sauti Soul Entertainment?
Also act as legal for them, as general counsel for the business, that is.
Are you aware of the matters that are before court today, this morning, in this proceedings?
Yes, I am.
There's a witness statement. There's a witness statement dated 2nd November 2022.
Yes.
You've seen the witness statement filed in court?
Yes, I am.
You confirm that that is a witness statement?
Yes, I confirm it, yes.
And that the contents therein, you'd want to rely on the contents therein with respect to your evidence in chief for this matter?
Yes.
It's dated 2nd?
2nd of November, 2022. There's a defendant's list of documents dated 7th November 2022. Have you seen it?
Yes, I have.
Would you like to rely on those documents in your evidence in chief?
Yes.
My lady, I wish to submit the witness to cross-examination. We'll be relying on the witness statement and these documents in our evidence in chief.
Is he producing the documents or not?
Are you producing these documents in the defendant's list?
Yes, yes, we are.
There's a documents in the defendant's list of documents of 7th November 2022, number 1 to 16, to 16, my lady. The bundle, defendant's bundle of documents.
Okay, duly produced.
Most obliged, my lady.
So is there anything you would like to clarify or elaborate on before cross-examination?
My lady, I think the witness statement is quite significant, contains sufficient contents. We'll, if any clarifications, we'll get it in the exam.
Okay.
Most obliged.
Cross-exam?
Thank you, my. I trust you're well today.
Yes, I am.
Good. For purposes of disclosure, you and I know each other from before.
Yes.
We were in law school together.
Kenya School of Law.
Yes, correct. You were admitted into the bar?
No.
Okay. And you have confirmed to the court that you acted, or you act as one of the directors of the first defendant
Yes.
and counsel for the second to the fifth.
Yes.
However, you are giving evidence on behalf of the first defendant, correct?
Yes.
Okay. And the second to fifth defendants are not here to give evidence for themselves?
No, I'm giving what is in my statement. Also covers that.
It's just to clarify, because your witness statement states that it is a witness statement for the first to the fifth defendants.
Yes.
Okay. So we're clarifying that you're only giving evidence for the first defendant.
First to fifth.
Okay. Right. So you have stated that you're qualified to speak on the matters pertaining to this suit, correct?
Yes.
You are qualified in matters copyright, intellectual property, correct?
Through practice, yes.
Yes. You've even given lectures, I believe, on this topic.
Yes, I have.
Okay. And you are specifically, oh, I beg your pardon.
Yes.
Thank you, my lady. You are aware of the specific provisions in the Copyright Act relating to copyright infringement, correct?
Yes.
Okay. Section 35 of the Copyright Act?
Yes.
Okay. What about Section 38, which creates criminal offense of copyright infringement?
I mean, I'll have to have the act in front of me.
Okay. But you're aware of it?
Yes.
Okay. And Section 38A, which creates an offense where infringement is committed by a body corporate. Okay. What was the nature of the advice that you gave to the first defendant as it relates to the musical works that are in question before the court? When the plaintiff brought their issues to the first defendant, what was your advice in terms of how to deal with her rights in the songs that have been brought to court today?
The initial bit was how do we come to an agreement on the split sheets?
Okay.
Yeah.
Was an agreement reached to the split sheets?
No.
Okay. The first defendant proceeded to deal with the songs Extravaganza when the split sheets had not been agreed.
Yes.
They made money from it.
The master copy, the master right in the song, yes.
Okay. From 2019 when the song was released.
Yes.
Okay.
Mr. Asige,
I beg your pardon.
you have to be careful about the pace you're moving at.
Yes, my lady, I am conscious and I will do my best.
The complaint was about the split sheets.
Yes, my lady, that was the question I asked.
The next question.
Should I continue from there, my lady?
Yes.
Yes. And sorry, I'm just taking us backwards for the benefit of the court. And the split sheets were not agreed.
This was after the fact, yes.
Okay.
Yes.
To date, have there been any agreed and signed upon split sheets in respect of extravagance?
No, not on Crystal's part. On everybody else's part, they've signed.
Okay. Have you produced any document to confirm that?
To
Any
confirm-
split sheet to confirm that there has been an agreement, a signed split sheet that excludes the plaintiff?
No, everybody's agreed on their terms
Okay.
on the split sheet,
Mhm.
except for the plaintiff.
Okay. When this split sheet was being agreed upon, was the plaintiff communicated with?
Yeah, because at the same time,
At the same time as when?
when we set the split sheets to, it was my IP law,
Mhm.
that was around October 2020.
October 2020. Okay. Before October 2020, had any split sheet been shared to the plaintiff or any of the other artists who were involved in extravagance?
No, but we had an agreement, everybody would get an equal share.
Everyone would get an equal share?
Yes,
Okay. An equal share of what exactly?
their rights in as songwriters
Mm-hmm.
and their rights as performers.
Okay. Okay. The split sheets that have been submitted by the plaintiff contain a conflated a conflated intellectual property agreement. Is that correct?
No,
Okay, let me break it down. It contains copyright rights, the split sheets.
yes,
It contains performers' rights.
yes,
Contains producers' rights.
yes.
Okay.
And it also contains the master right.
The master rights. Okay,
Yeah.
correct. It also names the first defendant as a co-writer of the song Extravaganza, correct?
Yes,
You are aware that in the Copyright Act, a company, a body corporate cannot be an author of a song, correct?
you need to point me to the specific section within the Copyright Act that says body corporate cannot be a owner of copyright. Because as a legal person, I believe they can.
Ask the question again.
Okay. The question I asked, my lady, is is he aware that a body corporate cannot author a song?
Are you aware? Answer.
Our body corporate has not authored the song.
No,
The question is whether a body corporate can author a song.
No, it can't.
Okay. So you say no, a body corporate, i.e. a company, cannot author a song.
Author, we need to be specific.
Write a song.
Write the lyrics within the song?
Yes.
No, it can't.
Okay. Sorry, you said it can, or it can't?
Cannot.
It cannot. Okay. I'd like to refer you, my lady, I would like to refer the court to the plaintiff's list of documents, list and bundle of documents.
Page.
Yes, my lady, so I'm just locating it. My lady, it is titled 21. The page is 21A, and the plaintiff's bundle of documents dated 23rd of September 2022. May I continue?
Mm-hmm.
What is that? Oh, do you have the document in front of you?
Yes.
Okay, great. Okay. The document in front of you. What is the that document for the benefit of the court?
It's a collaboration split sheet agreement.
Mhm.
Our standard collaboration split sheet agreement.
Mhm.
Yes.
Okay. And what date is it? Dated? At the top?
9th February 2020.
Okay. So not October 2020, as you mentioned earlier.
No, what I said was it was sent.
Okay.
Sent, not when it was dated.
Okay, so in October 2020, this document was sent to the other artists, but
No,
not the plaintiff.
Sent to my IP law
Uh-huh.
to, because it asked for the split sheet agreement.
Okay.
Yes.
But this document dated 9th of February was the one that was sent to the plaintiff when she made, when she brought issue with her rights, or her share of her rights in the song.
I share, yes.
Okay. And if you turn the page,
Yeah.
which is not dated, which is labeled 21B,
Mhm.
okay. At the top, where it says, you can see that there's a table,
Yes.
okay? And the table says section of composition, contributing artist, and split, and the publishers.
Yes.
Correct?
Yeah.
So, and then there's a list of intellectual property rights, correct?
Yes.
Which,
Move on.
yes. And so the one of the rights is production rights, correct?
Yes.
Another one is arrangement,
Yes.
okay? Another one is songwriting, lyrics, and composition,
No.
and that is performance.
Yes.
And the last one is
the
performance.
last one is performance.
Yes. And these are all separate and distinct intellectual property rights, correct?
These four elements are what make up composition.
Yes. That's not the question. The question is, those are separate and distinct intellectual property rights, correct?
Technically, yes.
Okay. Under production, who are the parties that are listed as producers of this song?
Polycarp Opportunity,
And his split is?
12.5%.
Okay. And the second producer,
Soul Generation,
and its split is?
12.5%.
Okay. All right. So there's the body corporate, which is listed there as a producer of the song.
Yes.
Okay. Let's go to arrangement.
Yes.
We have, who's the first arranger listed in this split sheet?
Polycarp Opportunity,
Okay. And his split is?
10%.
Okay. And the second arranger?
Soul Generation,
A body corporate, correct?
this is not songwriting.
It's an arrangement.
We have to make a distinction.
I'm asking the question. Soul Generation is listed there as a 10% owner of arrangement rights.
Yes.
In your understanding of authorship, is it just limited to the actual physical writing of the words, or does it extend to arranging a song? Isn't that part? Let me stop there. Let me break it down. I beg your pardon. In your understanding of songwriting, what constitutes songwriting?
Lyrics,
Mm-hmm.
melody,
Mm-hmm.
composition.
Mm-hmm.
Yes.
Yeah.
It comprises?
Lyrics,
Mhm.
melody, and composition.
Okay. And we can both agree that in lyrics, melody, and composition, it doesn't just get dumped anywhere in the sound recording, correct?
That's melody, and that's the lyrics and songwriting. It all comes together in one. Yes.
You have to arrange the song in a certain way so it achieves a certain sound, evokes a certain feeling, or tells a certain message, correct?
That's melody. That's
Oh.
not arrangement. Arrangement, just to clarify, arrangement in musical work is how the engineer of the song takes everything that's put together and arranges it within the whole composition. So where does the verse start? At which point is it 32 beats? Is it 16 beats? Is it 64? Right. So that is what arrangement is within when you're doing split sheet agreements. That's why you find most people who are within arrangement are either the studio engineer or the producers of the song, right? Because they're the ones who essentially say, here's where the chorus will go, here's where verse 1 will go, verse 2 is here. The bridge will be at a certain section of the song. Yes.
Okay. So in that arrangement, what this split sheet agreement seems to state is that the company, Soul Generation Records, is part of the arranger of the song.
Who paid for it. So Soul Generation being the people who paid the engineer, then he who pays for the means of production takes up that part of the split. Right? So, and I think the distinction here is what are the rights that can be taken up by individuals who actually do the work, or when you pay someone to take those rights. So work for hire, basically.
You do understand that copyright exists in the person who creates that piece of work, correct?
Or the person
or that
who-
artistic work.
Or the person who commissions that piece of work.
The person who commissions, how do they get a stake in that intellectual property right?
If you pay the person and it's on a work for hire agreement,
Yes, and the work for hire agreement is a form of assignment, isn't it?
yeah,
Yes. So a company, a body corporate, cannot be the originator or the original owner of any intellectual property right, much less a copyright,
I
correct?
believe you can. That's why music labels can own master rights, and master rights are very distinct rights within intellectual property.
All intellectual property rights are a form of property, correct?
Yes, they are.
And property can be bought and sold, correct? Just
Yes.
in the same way as land can be bought and sold.
Exactly.
Yes. And the only way that a body corporate can own an intellectual property right is if it has bought it, as you said, that Soul Generation paid for it, correct?
Yes.
And you paid it according to or pursuant to the provisions of an assignment agreement, correct?
Yes.
Or a licensing agreement, correct?
Yes.
Okay.
No. So, and makes this distinction again. On the production side, we paid for the production, right? And there were people in the room who were actually doing the production but did not want to be part of the split sheet. They wanted their money up front.
Mhm.
So on the production side, them being producers,
Mhm.
they were paid.
Mhm.
And in that sense,
Mhm.
then they're paid on a work for hire basis. On the production side, which then means the person who, the legal entity, the legal person that then owns that part of the production
Mhm.
is then the business.
But as a legal counsel for the first defendant, wouldn't you want to protect the interests of Soul Generation Records?
And that's what we've done.
Let me put it this way. If a producer says he doesn't want to be named in the split sheet but wants a direct payment, as you have described,
Yeah.
wouldn't it be prudent that an assignment agreement is executed to avoid any claim coming up in the future from that producer?
Yeah, which we did.
Have you produced any of that to
No,
substantiate
it wasn't relevant for this matter, was it?
or you felt it wasn't relevant for this matter?
No, on this, especially pertaining to this matter,
Mhm.
where the production and arrangement
Mhm.
rights pertain to 50%, 50% of the 50% in publishing,
Mhm.
where the plaintiff was not involved in any of these things, right?
Mhm.
Then it's not relevant to what we're doing or what we're discussing.
Okay. You have actually just now you have said to the court that production arrangement rights constitute, according to your split sheet, 50% of the combined intellectual property rights, correct?
No, that's not what I said. It constitutes 50% of the 50% that is publishing rights. So the split sheets mainly pertain to the publishing rights of the artists, not to 50% of the full rights to the song. Right? So that's why when you look at this, there is 25% for production, 25% for arrangement, 25% for songwriting, lyrics, and composition, and 25% for performance.
Okay.
So all this makes up 100%, yes.
Okay.
That's 100% of the publishing right, which is 50% of the rights to the total song.
The plaintiff's assertion is that each intellectual property right should have a separate split sheet. You are aware of this from the pleadings that have been filed?
Well, that's the assertion.
Okay, yes. And one of her grievances was that these split sheets, as they were produced to her or presented to her, effectively was diluting her copyright share in the song. You're aware of that? That is her argument. I'm not saying whether you agree or not. I'm just asking you if you're aware that that is her argument.
I mean, if that's what's in her plate.
Okay. All right. Let me ask you one thing, or maybe a couple of things. So if we go to production and arrangement, if you combine those splits, 12.5% for Polycarp Otieno, who is the third defendant in this matter, Soul Generation, the first defendant, gets 12.5%, that's 25%. That's a quarter of the entire 100% already, all right? Under arrangement, you have the third defendant, Polycarp Otieno, who has 10%. And Soul Generation, the body corporate, the first defendant, has 10%. And a gentleman called Ivan Quizera has 5%.
Yes.
You add all that together, you get 50%.
Yes.
Correct? When we go to the songwriting, lyrics, and composition,
Yes.
Each of the artists gets 5%.
Yes.
When you go to performance, each of the artists get 5%.
Yes, an equal share.
Okay, an equal share, according to your split sheet.
For their participation within the production of the song.
Oh, so for their participation, not for their songwriting and arrangement.
Songwriting is participation. So songwriting, lyrics, and composition, that is their participation within the song itself.
No, participation could be cheering, so we just need to be specific what participation means.
I'm being specific in the sense that their participation within the production of the song, songwriting, lyrics, and composition, and performance. So everybody got an equal share within that space.
Okay. So effectively, if we look at one of the artists, who's the plaintiff in this case, for her songwriting, she receives 5%.
Yes, equal to everybody else.
And for performance, she gets 5%.
Yes, equal to everybody else.
Which is a total of
10%.
10%.
Yes.
But 10%, the argument that we're putting forward is that 10% is a gross dilution of her copyright in this matter, because we're here about copyright.
So,
in fact, let me even be more specific. For her copyright, which would be comprised in songwriting, lyrics, and composition, it is only 5%, because performance rights are separate rights.
no, so we include them in all in the split sheets as combined, because a performance right is within the within public performance. So when your song is played somewhere, if it's on radio, if it's on TV, and such, in terms of if it's publicly performed in public, then that's where your performance right kicks in, right? So within the 25% left for songwriting, lyrics, composition, and performance, right? She has, well, sorry, within the 50% left, within that she has 10%.
Carry on.
Okay. Okay. Let me just, because I think we need to be very clear about the different the different intellectual property rights.
Yes.
Because what you're putting forward to the court is that you can conflate all these rights into one intellectual property right. And what we are saying is your split sheet that you're producing is effectively diluting the artist's intellectual property rights under the guise of this is what we usually do.
No, so under the guise of this is what we usually do, it is established in custom.
Custom or law? You know, those are two different things.
I mean, our corporate act is thin, and that's the reality.
Our what, sorry?
Our corporate act
Uh-huh.
is thin
Uh-huh.
in terms of what does it say when it comes to split sheets, right?
Mm-hmm.
But I think it's very clear, because we are in an industry, that number one, there are different kinds of rights, right? So there is the master right, which is the right to the sound recording, and this master right is given or is assigned to the person who pays for the means of production. Right? So essentially the person who produces the song, who pays for studio and pays for everything that is around it, mixing and mastering and such. Right? Then there's the musical works. Under musical works we have what we call publishing rights. So within those publishing rights is where your songwriters and your performers within the song fall, and your producers and the people who arrange the music. So your studio engineers and such, right? So to be, again, like you said, we need to be specific. Musical works is divided into two pieces. There's the master right and the publishing right. So we're not conflating. We're just making it clear that split sheets are meant for the people who fall within the publishing rights, because they have unique contributions that they made to the song, and those unique contributions come from their individual participation within the making of that song. And in that sense, those unique contributions have to be recorded. So, how our business works, right?
Now, before you go to how your business works, I just wanted to just clarify something that you've said. You've mentioned to the court that the Copyright Act is thin, correct?
Yes.
Does that mean that an individual or a party is allowed to make things up as they go along?
No.
Because they feel the act is thin?
No. I mean, so I think within the industry, there are many standards that someone can apply. And also in the interest of fairness, and also in a situation where our publishing, our customs and traditions, or let me say, our publishing industry is not the strongest, right? What we wanted to do was be in a position where we have everything within one split sheet, so that everybody understands who owns what. So if you see, the beginning of the split sheet is very clear, that master rights ownership will belong to the label. And then following that...
What is the master right ownership according to that agreement?
The right
The
to
split.
The right to exploit the song.
And what is the split?
It's 50%, and that is customary. within
Actually,
the
what it
music
says on 21A about master rights is all parties acknowledge and agree that Soul Generation Records Limited have 100% undivided interest to the master right of the composition, including and not limited to rights and discretions to commercialization, synchronization, reproduction, publishing, and all consents and first rights of refusal to the aforementioned rights.
Exactly.
So it's not 50% as you've just testified.
No, if you just read the sentence again, 100% rights to the. Let me read it again, so that we are. Just 1 second. Here it is. Right. Okay. That you have 100% undivided interest.
Mm-hmm.
Right. So it's not 100%. It's not 100% rights to the It's the 100% qualifies the interest in which we have to the master right,
Mm-hmm.
and the master right is 50% of any sound recording.
That's not what it says here. What it says here, according to the split sheet, is that you, from the first, as the first defendant, have separated master rights correctly as 100%, but when it comes to copyrights, you are now splitting them into all these different, or conflating all these other rights, so as you can give the bulk of the splits to the first defendant and directors of the first defendant. Isn't that what is happening here?
No, no, absolutely not. And I'll just read the sentence again, together. All parties acknowledge and agree that Soul Generation have a 100% undivided interest to the master right. The interest in the master right
Is undivided.
yes,
Yes.
because the master.
But then you proceeded to divide it
No,
in
no.
the next page.
There-
Isn't that the case?
There are two different rights. The master right is the right to commercialize the song. So, I think
I agree with you on that. I'm not disputing that.
If-
My question to you, Mr. Omambia, is the master rights you have kept to yourself, and correctly so, because that is a separate intellectual property right. 100% undivided interest. However, when it comes to copyrights, in number 2, paragraph number 2, you have proceeded to conflate it with performance rights and production rights in order to skew the splits in favor of the first defendant
No.
and a director of the first defendant. Isn't that the case?
no, it's not.
Okay. You are aware that...
Just a minute,
I beg
Mr.
your
Asige.
pardon.
Let's go back
Yes.
to these master rights.
Yes.
What is your understanding of 100% undivided interest? Because
That's-
you've said, I want this one to be very clear
Yeah,
for my records.
yes.
Because you say the master rights are 50%. 50% of what?
Of the sound recording. So the sound recording is what you hear when you go, let's say, on Apple Music or Spotify and play the music. So that sound recording, can I demonstrate it to the court? May I,
Yes.
please? So, I think it'll be easier this way, if you allow me.
Mm-hmm.
So this is the sound recording. What was recorded in studio and then affixed to the hard drive, and then now eventually published to the public, right? So this sound recording is divided into two pieces. For the person who paid or made sure that there's a means of production and paid for it, and then paid for its marketing and all those things, 50%, which is the master right. Now in this, here's where the 100% undivided interest to the master right lies. Now, here is the publishing rights. The publishing rights, or as has been defined in the court, copyright is for the people who individually participated in production of that song. And their rights are also undivided, right? For the individual and unique contributions to the composition. And in that sense, that's where you have the producers, the arrangers, the songwriters, and the performers. So in this 50%, the right to this 50%, then 100%, and the right to this 50% needs to be divided into from that. So that's what I was saying. It's 50% of 100. It's 100% of 50%, right? And this is what we're discussing.
The other 50%. Okay,
The other
proceed.
50%.
Okay, carry on.
So the undivided interest is within this 50%.
Of the sound recording. Okay, carry on.
So according to what you're describing, the master rights are 50% of what is appearing on the following page. Is that what you're saying?
No.
The splits.
No.
It's a 50% of what? The master rights as you've described them in this document.
Of the sound recording.
Mm-hmm.
Yes. What is appearing on the next page is the other 50%, which is the publishing rights to the song, and which is, we state very clearly here that they are the corporate interest to their individual and unique contributions to the composition.
According to what you've described to the court and the logic you're trying to put forward, if that master right is the 100% undivided interest is 50% of another right, then wouldn't that mean that, wouldn't the logic follow that then you cannot deal with your master rights without involving the other parties?
No. So that's not how it works. The master right, right, he who pays for the means of production owns the master. So I think we need to make it very clear in the sense that on our side, it is an investment into the sound recording, right? And that investment needs to be repaid in either sales of the sound recording or distribution of the sound recording or licensing of the sound recording or digital sales and streaming of the sound recording. So that undivided interest for the master remains in that sense. And that's why when the conceptualization of music rights came into being, was how do you divide the two so that on the public performance side, right, on the royalty collection side, that the artists have how they can collect for their individual contribution.
Okay.
Yes, carry on.
Because I feel like we're going around in circles. What does the master rights allow the owner of the master right to do with a sound recording, such as extravaganza? What does it allow them to do?
So,
because we're not disputing whoever pays for the means of production, etc. But what does a master right, owning 100% of a master right, allow the owner to do?
to distribute the song, to reproduce the song. Basically the commercialization of the song.
Okay.
Which is distribution to your, as we sit now, your digital service providers, your Spotify, Apple Music and such.
So don't you agree that once the commercialization is in progress, some money will be made, correct?
For the master rights holder.
For the master rights, yes.
For the master rights holder. as the person who paid for the means of production,
Okay.
who pays for the marketing of the song, who pays for the staff to market the song, who pays for the album covers to be designed, the song covers to be designed, the photo shoots, the music videos. So for the master rights holder, yes.
And how does the copyright owner get paid? How do they get recompensed? How do they earn a living from their contribution, whether in part or in whole, to that same song which has a separate master right?
Okay, so that's very clear. In that situation, and if you look at the next page, which is within the 20th bundle of documents, 21B, right? We have the spreadsheet is like, as you had stated earlier, the spreadsheet is divided into a number of sections. There's a section of composition, contributing artist, split, and publisher, right? And if you see under the within the plaintiff's role, under publisher, we don't have anything for her, right? Because we don't know who her publisher is. Now, royalties are collected on the publishing side by businesses called publishers or PROs, publishing rights organizations, right? So upon, let's say, radio play of the song, right? Upon public performance of the song, which are monies collected by licensed bodies within different countries. So for like our situation in Kenya, it was formerly known as PRISC, I think now it's called PAVRISC. That's how nations collect. Then within those nations, the publishers who are registered to the PROs can then collect on the behalf of the artist. And then depending on the publisher's agreement with the artist, then the artist gets what their royalty is. Now, if an artist is self-administered on publishing, right? Like some registered businesses. So in, let's say, a situation of an artist called DJI, they would start a business called DJI Publishing, and then they would register, they would use that business to register with the different PROs, either locally or internationally. So that's how the people on the side of production, arrangement, writing, lyrics and composition and performance, that's how they collect from their share, from their 50% of the 100%.
So you're still contending that everyone's individual, intellectual property right, whether it's copyright, whether it is performance rights, whether it's production rights, is some form of fraction of some imagined whole. Is that what you're contending?
No, it's not imagined.
Oh, so this is real. So the Copyright Act does state that these individual rights can be conflated into one right, and then everyone gets a little piece of that in terms of copyright performance, but the master rights, or those you can take 100% and keep to yourself.
And so this is why I say our act needs a few more amendments, right? Because our act does not directly address on the music rights side how that works. And I think,
and even though, yes, we can take your point that the act needs amendment, but is this how you're choosing to carry out the amendments? Is this how the first to fifth defendants are choosing to implement so-called amendments?
no, that's
to the detriment of artists?
And that's what I've said. What I've said is, this is what happens on a standard basis, right? For us, whatever is in this table are what encompass publishing rights within a sound recording, right? So there are two parts of it. And I think I've explained it pretty clearly.
Yes, I don't think you need to repeat.
Yeah,
You said that
that's-
so many times, it's already recorded. I mean, I've captured it and it's recorded also.
Move forward. You do admit that that the song Extravaganza was dealt with or commercialized, as you put it. When was the Extravaganza commercialized? Apart from the release, that's one that is obvious it was commercialized in that way, and that was in 2019. Where else has it been commercialized? Has it been synchronized?
Yes, yes, yes.
And it was synchronized in how many synchronizations are you aware of? One. And that synchronization is
Country Queen.
Country Queen. You have not synchronized with any other entity.
Well, not that I know of.
Okay. And when did you synchronize?
I need to check the agreement.
Mm-hmm.
Must have been 2021.
Mm-hmm.
Yeah.
Okay. Also, well, let's bring another song that has been in contention. There's the song Lenga and Ukiwa Mbali. You're familiar with those songs?
Yes.
Yes. And those were commercialized, correct?
Yes.
With the sixth defendant in this matter, correct?
Yes.
KLM.
Yes.
Okay. And you entered into an agreement with them.
Yes.
And you're familiar with the terms of that agreement.
Yes, I am.
Okay. Now, my lady, I refer the court to the plaintiff's further list of documents dated 6th of May 2024. The document, the page 2A, the top right. You recognize that agreement dated 12th of September 2019?
I don't have it.
I don't have it. Further list of documents, 16.
Yes, I do.
Okay. Move forward. You do admit that that the song Extravaganza was dealt with or commercialized, as you put it. When was the Extravaganza commercialized? Apart from the release, that's one that is obvious it was commercialized in that way, and that was in 2019. Where else has it been commercialized? Has it been synchronized?
Yes, yes, yes.
And it was synchronized in how many synchronizations are you aware of? One. And that synchronization is
Country Queen.
Country Queen. You have not synchronized with any other entity.
Well, not that I know of.
Okay. And when did you synchronize?
I need to check the agreement.
Mm-hmm.
Must have been 2021.
Mm-hmm.
Yeah.
Okay. Also, well, let's bring another song that has been in contention. There's the song Lenga and Ukiwa Mbali. You're familiar with those songs?
Yes.
Yes. And those were commercialized, correct?
Yes.
With the sixth defendant in this matter, correct?
Yes.
KLM.
Yes.
Okay. And you entered into an agreement with them.
Yes.
And you're familiar with the terms of that agreement.
Yes, I am.
Okay. Now, my lady, I refer the court to the plaintiff's further list of documents dated 6th of May 2024. The document, the page 2A, the top right. You recognize that agreement dated 12th of September 2019?
I don't have.
That hearing, correct?
Yes.
Okay. And it relates to what exactly? What is the subject matter of this document, of this agreement?
Well, it's for pieces of content that we had a discussion around creating.
Pieces of content?
Yes.
What pieces of content?
So there's musical works, there was music videos. So there's the audio part, musical work. Then there's the music videos, audio visual. And lastly, there was still photography, some BTS videos and such.
If you look at, I think it's a recital, I believe that, yeah, recital D of that same page.
Yes.
Okay. It says there, unless the context otherwise requires, each obligation imposed on the artist under this agreement shall be continued as an obligation on the label.
Yes.
To comply with such obligations.
Yes.
Correct?
Yes.
So there were certain obligations to be carried out by the artists.
Yes.
The artists are defined in recital B as Bensol, Mviri, Kaskazini, and the plaintiff herein, correct?
Yes.
Okay. Who are the signatories to this agreement?
Natasha and myself.
Natasha. Who is Natasha?
She was then the general manager of Sauti Records.
Okay. And on behalf of the sixth defendant?
It was myself.
No, sixth defendant is
Sorry.
KLM.
One second. I think the witness was robbing me there. I can't see the other.
Okay.
Yeah. It's up there.
And also in this agreement,
Yeah.
if you go to the Soul Generation Records, the top number one, the first party, you assign yourselves as for the artists, correct?
Yes.
Okay. As far as the plaintiff here is concerned, was there an agency agreement entered into to allow the first defendant to act on her behalf?
Not a written one, but a verbal one.
A verbal agency agreement?
Yeah.
Okay. But that then means basically there's no proof of an agency agreement.
There is some proof, in the sense that even during some of the undertaking of these obligations, when we were having discussions not only with the plaintiff, but also yourself, right? And within this whole period.
Mr. Mambe, you've said that you're the legal counsel of Soul Generation Records.
Yes, I was.
Wouldn't it be according with due diligence to ensure that you have something in writing to confirm that you are the legal agent that you're purporting to be?
Yes, it would.
And there is none on record that you have shown to the court?
There's a development agreement where we...
Was that signed by the plaintiff?
It was sent to the plaintiff, it wasn't signed.
Then what? Okay, so it wasn't signed. Defendants' ignorance to the industry or lack of due diligence that they will just accept it and agree to deal with you?
No.
Okay. The artists are mentioned several times. This is a very long. And the artists are also, there's also parts here, and I read this yesterday. I don't know if you were here to listen. On page 2D, there's a clause, page 2D of the same document. Yeah, if you go a few pages ahead, page 2D, there's a paragraph that says the artist acknowledges and agrees that KLM shall be the co-owner for the term of this agreement, and it goes on and on. Right?
Yes.
You've seen that part?
Yes.
And that is your agreement that you signed?
Yes, and we did discuss it with the artist.
Isn't it an egregious lapse that you would have obligations for the artists who are not signatories to this document, neither do they have any knowledge of this document? Isn't it a serious lapse on your part?
No, we discussed it very clearly with the artist. And that ownership is on a license basis.
How would the artist be bound to a document they're not signatories to? You're a lawyer just like me.
I understand, but
Yes.
we did have the discussion, it was agreed, and that's why those same obligations that are on the agreement were affected, not just by us, but by the artists themselves.
So if the artist refused to perform any of these obligations, which they clearly had no knowledge of, then they would not be in breach of this
They
document.
wouldn't have performed those obligations and even had the meeting with the KLM team if they didn't have a clear view of what we were asking them to do.
Did Soul Generation share this copy of this agreement with the artists?
This
At the
particular-
time.
No, we didn't share it.
When was this document actually, when did this document come to light?
This particular document. I mean,
When did it come to light?
I believe those parts you had asked for it.
Yes.
Yes.
Yeah. And when it was asked before the suit was filed,
Yeah.
was it produced then?
No, it wasn't. But we
And
did-
wasn't it produced after this suit was filed and produced by your own lawyers?
Yes.
Okay. So you're basically confirming that this is a document that was entered into between yourselves, the sixth defendant, without the knowledge or consent of any of the artists who here are tied to a whole host of obligations amounting to about 17 to 16 pages worth.
There was full disclosure on what the obligations would be, and that's why those obligations were carried out by the individual artists. There was full consent, and that's why those particular obligations were carried out in terms of, getting the music done, shooting the music videos, and eventually, the handover of the music.
Again, let me just go a little bit forward. You do admit that you continued to deal in these, the recorded works that are before the court, even though there were no documentations, split sheets signed, any agreements, nothing of that nature. You do confirm or admit that, don't you?
On spreadsheets on our side, yes.
Even negotiating with the plaintiff, you were dealing with extravaganza, you had already dealt with Lenga and Ukiwambali. Correct? Isn't that the case?
As master.
When did you deal with the Netflix? When was that deal signed, the Netflix deal, to use extravaganza?
I need to have it in front of me. So
Okay.
I can confirm the date.
But that was done before any split sheets were agreed. So that
As the
the
master
first to the
rights.
fifth defendants were making money to the exclusion of the artists.
Again, as the master rights holders, we have an interest, right, to the master right, which means the commercialization of the song, right? And in any situation, if you look at how we're supposed to earn, it is very clear that we're not infringing on the earnings of the plaintiff. So if you're saying we're earning, yes, we do earn from the master right royalties that come from that.
I'd like to refer you to your witness statement, paragraph 2. Because there seems to be a pattern that is shaping up. You say that the second to fifth defendants and myself are also director shareholders of the first defendant, founding the business that I presume is the first defendant, in early 2019 with the mission of developing iconic African musicians who would write soundtracks to people's lives. That is what you have stated there.
Yes.
So basically what you're saying to the court is that there's a pattern of the first to the fifth defendants making iconic music that is not disputed. I mean, I'm sure everyone in this courtroom is a fan. But however, you are about yourselves first.
Don't lump everyone.
That's what I said, presumably, Your Honor. Presumably.
Yes,
I can be refuted. So basically what you're saying is you make iconic music and you create documentation and split sheets that makes sure that Soul Generation and Sauti Soul members get their cut first, make sure they're getting the remuneration, but when it comes to the artists and their royalties and their ability to, make a living or earn royalties for their life plus 50 years, according to the Copyright Act, that is none of your concern. You are happy to make your own money and you're happy to leave everyone else to fend for themselves
I think
in the making of this iconic
I
business.
think that's a gross misrepresentation.
But you have just told the court that you are able to deal with this music using this master rights that you have said is undivided, indivisible, 100%, however you've explained it. So that gives you room and permission to deal with these musical works. But when it comes to agreeing the split sheets to enable your artists to even make a living, you don't care.
Okay, let him
Again,
answer.
I think that's a gross misrepresentation of, number one, part 2 of my written statement and what you're trying to present to the court. Ours is to make sure that, number one, everybody has an equal share for how they participated within the music, the sound recording. Now, the master right is their exploitation, right? So we have to exploit it in a sense that.
Is
so
exploitation limited?
Am I allowed to finish?
Okay, proceed, please.
To the court, am I allowed to finish that?
Please proceed.
Right. On the exploitation in terms of getting the music into the space so that it can be publicly played and consumed, that exploitation requires us to market and do all the other things surrounding that master right, so that as it follows, then the people who are on the other side, because publishing rights are residual rights in the sense that they come from how well the song is marketed and put out there into the public so that it can generate royalties for the other 50%. Right? So, in this case, what we're saying is, no, this is not our business. No, we have not done this. There are other artists who have come from our label. Second one of those is Benso, who is thriving, and Viri, who is thriving. As such, I can't accept what you're trying to say simply because we do not do that. We don't.
So basically what you're telling the court is that you have favorites.
Again, no.
Okay, that is fine. Let us go forward.
Let me answer your question. What I'm trying to say is the ones who we worked with to the end of our natural relationship are thriving. They thrived under us and they keep thriving after us. Right? We are not in the business of playing favorites. And
So you
I would really appreciate it if you don't put words in my mouth. I think I was very, very clear in saying how we show that how we develop our artists is those two. I did not say we favor them or anything of that sort.
You said Vensol and who else?
Mviri, the storyteller.
Who?
Mviri,
Oh, Mviri.
N-V-I-I-R-I.
Okay.
Yes.
and you're saying under oath that Mviri, the storyteller, and Bensol are thriving.
Yes.
This is what you're swearing to. That you're saying under oath. Now, I want that to be clear.
Yes, they Bensol
Because you
and
don't want
Mviri-
to perjure yourself, and then it turns out to be
Bensol
completely
and
different.
Mviri are thriving.
And then your
Yes.
credibility to the court becomes non
Very
sequitur.
Yeah, they are thriving.
Okay. The spirit of thriving. Let's see. So there's this song called Intro. Okay? Intro was the first song of the second to fifth Defendants album named Midnight Train, correct?
Yes.
It was released in, I believe, early 2020.
No.
Which year was it released?
June the 5th, 2020.
Okay, June the 5th of 2020. Okay? Right. When the negotiations between the plaintiff and yourselves were ongoing, this particular song or musical recording, musical work, was not being discussed, correct? In the initial stages.
I believe there were conversations between the plaintiff and, as per her plaintiff, the second.
But at the beginning of the negotiations around 2019, the end of 2019, when she was let go by the first defendant, that song was never on the table of discussions, or rather it was not really being discussed, correct?
Yes, because
Yes.
we don't have the rights to discuss that song. Yeah.
We'll come back to that. And then Midnight Train was released in June 2020, as you said, correct?
Yes.
While all these negotiations were happening, correct?
Yes.
And the first song of that album is called Intro, correct?
Yes.
And the plaintiff is a co-author of that song, correct?
Yes, one of the all.
And she was credited as such on all the platforms where it was released, correct?
Yes, she was created by us.
Yes,
Yeah.
correct. So, and then that song now came into play in the negotiations, correct?
Yes.
And you responded, as you've just said, that you did not own the rights for that song.
Yes.
And why didn't you own the rights of that song?
Because the label Universal
Mm-hmm.
paid for the means of production,
Mm-hmm.
and hence
Mm-hmm.
they then end up being the master rights holder,
Mm-hmm.
and they are the ones who are responsible for the commercialization of the album, which then includes the song.
Okay. Did you inform the plaintiff that that song was going to be part of that album before it was released?
It was the responsibility of Universal Music Group.
No.
Let me-
I'm asking a very direct and simple question. Did you, as Soul Generation, or the second to fifth defendants, as you say you're their legal counsel, did any of those entities think to say, this song is co-written by the plaintiff, let us just shoot her off an email, send her a split sheet, inform her that we're releasing it as the opening song of their album, their latest album, so that we make sure we have all our letters, our I's dotted and our T's crossed, and all the legal issues are dealt with, and we can move forward and release this album without any worry that there'll be any infringement claims?
Again,
Did you or didn't you? Simple.
again. I think it's
Did you or didn't you? That is the question.
It's not a yes.
Because you're kind of going around in circles, but I'm asking you a very direct
I
question.
think there has to be context because
No, the question is
So
very
did
simple.
you or did you not? And if you didn't, why?
okay, we did not. Simply because, number one, at that time we already had the conversation with Crystal. She was not talking to basically anyone. Secondly, upon release of the song, it was very clear that she had been credited. Why? We had informed Universal very clearly who all the songwriters, everybody who participated within Midnight Train, we had informed Universal. Because they were the master rights holders, it was their responsibility to then have that conversation.
So you had informed Universal
Yes.
Records
Yes, and that's why
about
she
what?
about her being a co-writer within the song itself. And that's why she was credited on all platforms as acknowledged by them. And that's why she was credited, so that then Universal can, so they know who to get in touch with.
So,
Yes.
so according to you, a credit is enough. You don't need to tell them anything, you don't need to agree anything with them. Credit, enough. And you can go ahead and deal with that song with Universal Records, a third party, and the artists can just figure their way out through it in terms of commercializing her share in the intellectual property rights in that song.
No, I believe we're in a quarter five. Right?
No,
So,
I'm asking
I'm
you
not-
a question about your attitude, or the first defendant's attitude to which you are here.
I don't think our attitude is in question. I think what's in question is,
No, your attitude is in question because it is informing how you are dealing with intellectual property rights.
no,
Yes.
what we did was follow up and make sure that everybody who was part of Midnight Train was credited. What then happens is the person who owns the song isn't supposed to get in touch with the people who are part of the song, right? Now, if you are credited within the song, it is not upon us to make that agreement. It is upon the label, and it is upon even the artist. That's why we credited Crystal. Then what happens in a situation is that if I was her publisher,
Can I pause you there just so that the court can record what you said? Beneficiary of all benefits, all monies, all synchronization of that album, Midnight Train,
Universal Music,
not Sauti Soul.
no.
So they have not received a single penny from that album. That's what you're telling the court.
Royalty check 2 years ago for our participation in songwriting.
So you've received, the second to the fifth defendants have received remuneration from that album.
Yes.
So it's not just Universal Records who have received monies from that album, or any profits from that album.
And the producers who won that album,
Okay.
and the other songwriters,
Oh, so it sounds like everyone is getting paid except the plaintiff.
which means we did get
Which
in touch.
means then there is a lot of bad faith in how you're dealing with
I think
this.
again we're in a court of fact, not court of feeling.
Okay, the fact
My
is that,
situation-
the
what-
fact,
the
I
fact
put it
is
to
that-
you.
The fact is that we informed Universal.
Mhm.
They did get in touch with everybody. And upon, I believe it's in one of my emails, and we said we had informed, we get this, when we were having a back and forth end of 2020, we advised that it would be prudent to get into a publishing deal and ask your publisher to then follow up with Universal on specifically those bits, on specifically the song intro, because we did inform them that Crystal was a co-author, and if we were acting in bad faith, I think it would have been very I think shooting ourselves in the foot to credit.
Is there any documentation that any correspondence you provided to the court that you did inform the plaintiff that her song intro, or a song that she co-wrote intro, was about to be the opening song of the Midnight Train album, so that you could sort out all the legalities? Because these negotiations actually proceeded till October 2020, correct?
Yes.
Yes, October 2020, which is when the first defendant agreed to sign over the master's rights to Lenga to the plaintiff, correct?
We offered.
And the master agreement was signed, correct?
Yes.
For Lenga.
Not we agreed. So that we agreed.
Yeah, agreed. No, there was an agreement.
However,
And that is in the documents.
we offered the master rights to Lenga, and we also offered the rights to every single song that we had paid for recording, which Crystal had recorded with us.
The master rights were signed. The album, Midnight Train, as you said, was released in June 2020, correct?
Yes.
So this means that in the back end, while negotiations were happening regarding the musical works that the plaintiff was aware of, the first to fifth defendants were at the back end proceeding to deal with the song intro without her knowledge and without her consent and to her exclusion. Isn't that correct? You said it's a court of fact, and these are the facts that have been laid out.
How will we deal with them?
No. Don't answer a question with a question. The question is, you said that the master agreement to Lenga was agreed in October 2020, correct?
Yes.
The album Midnight Train was released in June 2020.
Yes.
Negotiations had started at the end of 2019 to October 2020 when the Lenga master agreement was signed, correct?
Yes.
At no time during that period, at least until June, had any conversation happened with the plaintiff and yourselves to say, oh, there's this song you co-wrote, we're using it in Midnight Train album, let's, meet up and, sign up the paperwork. Because that's also correct,
It was
isn't it?
not our responsibility to sign up.
Whose responsibility is it
It was
then?
Universal Music Group's responsibility. I think.
If you're no. Let me just be clear.
Yeah.
Because there's a little bit of a dance that you're doing, and I want the court to be very clear that the facts as are stated in the documentation that has been provided, that you have not provided any documentation to say you gave the plaintiff information that that song was going to be used in the Midnight Train album. The Midnight Train album was being marketed and released as a production of Sauti Soul, not as a production of Universal Music Group, correct?
No.
No, correct?
No. It was.
What is the name on the album cover of that album?
Midnight Train.
Is it Midnight Train? And who are the credited artists for that album cover, on that album cover?
Everyone credited with.
No. What is the name that is written? There's above Midnight Train, there's the artist name above. Who is the artist written up there?
Sauti Soul.
Sauti Soul. There's nowhere on the album cover that is written Universal Record Group, correct?
It's in the corner of the album.
So the primary beneficiaries to the money that is being made out of that album is Sauti Soul, regardless of what assignments or agreements they've done in the back end, correct?
Universal Music Group, and I believe we produced the agreement for that. We produced the agreement for that.
Again, when was that agreement brought to light? When was that agreement brought to light? Was it brought before this suit was instituted?
I don't think that when it was brought to light was relevant. What we did.
It wasn't relevant to this suit?
I'm saying when it was brought to light was relevant. We had made it very clear.
It is relevant. Because you are telling the court that the person that the plaintiff should have been dealing with is Universal Music Group. So how does the plaintiff know who they're supposed to deal with if that information is not made available to them?
We had made it clear.
To whom?
to you, once we had started when we started having the conversations around this, and there were demand letters back and forth, and we within one of our responses to your demands, we did make it clear in the sense that on the universal side, on the ITRU side, the conversation should be had with universal.
So what you're saying essentially is that it is okay for the first defendants, or the fifth defendants, because this is involving an album that was released by the second to the fifth defendants. It is okay for these parties to go and get a songwriter, an artist, anyone, come up with song lyrics, arrangements, etc., whatever components constitute a song, record that song, produce it, and then go and deal with it with a third party, and then tell that rights holder that, hey, it's not our problem, go find Universal Music Group in where? South Africa, isn't it? Isn't that where they are based, Universal Music Group, according to the agreement that is filed? Isn't that where Universal Music Group is based? Yes. In South Africa?
Yeah.
So an artist of little to no means, any artist, is supposed to climb that uphill battle, while the fifth defendants sit pretty knowing they have made their, whether it's the initial cut or future royalties. And that doesn't seem unjust to you, or unfair, or bad business practice, apart from it being against the copyright laws?
I think
that seems okay to you?
I think we need to put some things in context.
Now, I've just asked a question because you as a member of the fifth defendants, and you as a lawyer that you have said you are, knowing what copyright law is, because you've given lectures on copyright law, as you've told the court, and you understand the business, as you've told the court, and you understand that the copyright law in Kenya is thin, right? So to you, in your expertise and in your knowledge and your professional knowledge of what is just and fair, does that sound right to you? Yes or no?
I think you posed the 2 million question. It can't be yes or no.
You have talked too much, Mr. Asige, until now it became, like comments. Because it's too much.
Okay, which I can rephrase. No, but what I'm trying to do, my lady.
To the extent that you lose him.
No, I think he understands, but I will repeat it and I'll break it down.
Can you just narrow it down and ask the question?
Okay.
Ask the question.
Yes, my lady. I'm just making it shorter in my head. So what you've said, Mr. Mambia, is that the fifth defendants are able to collaborate with other artists, create music with them, and then deal with that music with third parties. And then when that collaborator wants to assert the intellectual property right, it is just unfair for you to say, well, we've dealt with another party owns it in South Africa, Universal Music Group. So, too bad, you deal with it yourself. Does that sound correct to you? Or just? Or in line with the copyright laws or the intellectual property laws of Kenya?
That's a question now answered.
Okay. I think context is important. Number one is that when we're having these discussions are not, again, they're not the most friendly of discussion. Right? And secondly, we're dealing with the issues as raised. That's number one. On why it wasn't brought up between June and October. And when it was brought up, we thought it prudent to direct the plaintiff to the people who would handle the situation most expediently, because, and this is through proof of the credits that were given to the plaintiff, is that we had informed them that she is a co-writer. Right? So within that, it was our expectation that the label would have dealt with it. And when it was raised, it was our expectation that upon directing the plaintiff to the right people to talk to get it dealt with expediently, they will be able to reach out to them and make sure that it is sorted, because we had informed Universal that she was a co-writer within that one song in the 15-track album, and to make sure that she is credited. We did not act in bad faith, simply because we made sure that the plaintiff is credited for what she was doing, for what she did for that song, which is very important, right? So no, to answer your question.
Does a credit mean?
We do not act in bad faith. And where you've asked, are we acting against copyright law? No, we're not. Especially when it concerns this song, right? Simply because, again, her credit was given, and yes, two parties did not communicate, but that didn't. If we're acting in bad faith, in that situation, I think people acting in bad faith don't intentionally shoot themselves in the foot.
Okay, have you provided any proof of this communication that you had with Universal Music?
The proof is in the credits that were given.
No, the conversation, the correspondence.
Is in the credits.
No, a credit does not equate to a correspondence. Have you put...
Like you said, Universal Music is in South Africa. How would they know Crystal was part of the songwriting group?
Answer the question. It's a specific question. Answer that question. Don't evade. Because that's what you're doing.
So there's nothing, we cannot rely on what you're saying about that correspondence. Is that correct?
I think we can rely on your plaint, which says that she was duly credited.
Does a credit equate to monetization or enforcement of that credit?
The credit allows for the plaintiff to instruct her publisher to then enforce that credit.
So, in conclusion, there have been several instances where the fifth defendants, as we have through this cross-examination, both and the third parties being Universal Music Group South Africa, the Netflix producers for the TV series Country Queen, and the sixth defendant. So you have shown that there is a pattern of dealing with musical works involving other artists to their exclusion. Isn't that correct? Regardless of the reasoning and what you feel about what you're doing, isn't that a pattern that has been established? Yes or no?
No.
It isn't a pattern. It's just coincidence.
So to the exclusion. I believe on the Country Queen agreement, there is the songwriters who are more credited. Mm-hmm. Right. And on that side, we have not earned anything until this matter is resolved.
And my final question, are you aware where the plaintiff has received a single shilling for any of these artistic works that have been forfeited? Has she received anything?
I think it's her responsibility to get the publishers and the publishers to chase those funds.
Her responsibility?
Yes.
Okay. My lady, I have no more questions.
Continued in the next available date, and the dates available are for next year.
Yes, my lady.
Which dates are available? And the times we have available are for 2 p.m. in the course of next year. In March. Yes. Which one is 2 p.m.? None. So 23rd and 24th of March,
2026 at what time, my lady?
2 p.m. All the other dates are taken in March, and the morning time is already taken.
Very well, my lady.
You may sit down, Mr. Murphy. Okay, thank you for your patience. So the time now being 1:50 p.m. and noting that I have a bar bench meeting to attend together with other judges and lawyers in tax division. The case is adjourned. It will be heard on 23rd and 24th March 2026 at 2 p.m. in open court.
Most obliged.
We're most obliged, my lady.
So see you next year, probably.
Wish you for those of us who want to see you.
Thank you.
Thank you.
Have a good afternoon.